The House passes an assault weapons ban for the first time in decades. Plus, Duke's Andrew Willinger discusses the fallout from the Bruen ruling. That and more on this episode of the Weekly Reload Podcast.
I made the devil run. I gave him poison just for fun.
All right, welcome, ladies and gentlemen, to another episode of the Weekly Reload Podcast. I'm your host, Stephen Gutowski. I'm also the founder of thereload.com, where you can head over and check out our reporting today and sign up for our free newsletter or purchase a membership if you want to get exclusive member benefits, like, for instance, getting this podcast a day early, or getting access to hundreds of exclusive pieces of analysis and stories about gun news across the country. This week, we are going back to the biggest Supreme Court ruling on guns in over a decade, the Bruen decision that struck down New York's restrictive gun carry law and is likely to have wide-reaching consequences from here on out. And I wanted to bring on somebody to give an interesting perspective, a different perspective. We've had Charles Cooke from National Review on. We've talked about this with Cam Edwards from Bearing Arms, and this week we're going to talk to Andrew Willinger, who is the executive director of Duke's Firearms Law Center. So, Andrew, welcome to the show. Can you give people just a little more background about yourself?
Absolutely, yeah, and thanks for having me, Stephen. I'm really glad this worked out. So, as Stephen said, I'm the executive director of the Duke Center for Firearms Law, which is a center housed within Duke Law School that encourages balanced scholarship about the Second Amendment. We host events and symposiums, and we also have the Repository of Historical Gun Laws, which is a collection of about 1,600 laws from medieval England up to the 1930s in America that's hosted on our website, firearmslaw.duke.edu.
Yes, and that's a repository that I imagine is going to become perhaps even more trafficked by a lot of judges.
I think it already has.
In the wake of this, yes, because that's one of the key takeaways from this ruling in Bruen, correct? The sort of the historical tradition of gun regulation in the United States near the founding era, or perhaps the Reconstruction era, and how much importance that'll have on whether or not modern gun regulations are constitutional under the Second Amendment. Can you just talk about your view of the Bruen decision generally? I'm just interested in your perspective on what it says and what it means. Absolutely.
Yeah, I know you've had some guests on to talk about Bruen before, so I won't do too detailed a summary, but at a high level, the plaintiffs in this case were two New York residents. I think they lived in upstate New York. And so not in New York City, but they had applied for permits to carry concealed weapons, sort of without restrictions, right? So not just for hunting or target practice, but just to carry them in public, and been denied. And New York's permit system required applicants to show what's called proper cause. So this is there are about 7, or depending on your count, about 7 states that had a similar system. And the way that New York state courts had interpreted this proper cause requirement was that it meant that an applicant had to show some special, extraordinary need for self-defense, right? So it wasn't enough that they said, there have been robberies in my neighborhood and I'm scared. Something like that's not enough. You have to show that, there's something like an actual threat made against you. You have a stalker or something like that.
Documented threat, right?
Exactly.
Police report.
Exactly.
Stuff like that.
And so the petitioners in this case challenged that law, and the Supreme Court held that the law was unconstitutional. And I think there's two high-level parts of that decision, one of which was not all that controversial, and one of which is very consequential. And I think we'll spend most of today probably talking about that second methodological part, right? But the first part of the holding is that the Second Amendment protects the right to carry arms for self-defense outside the home. And that's something that lower courts had mostly accepted, even though, Heller and McDonald, the earlier cases, dealt with bans on guns in the home that extended into the home, and you had to keep your gun in an unoperational state, as with the DC law and Heller. And so this is, as I said, it's something that was sort of generally accepted. It's something that the parties in this case agreed on, that the Second Amendment extended outside the home. And so that's the first part of the holding. And the second part is the more notable, the part that will have tremendous consequences for Second Amendment cases going forward, and that is that the court announced a new history-focused approach to deciding, after you make that initial determination that the conduct is protected by the Second Amendment, you then, the government is required to come forward with evidence that the regulation at issue is supported by the nation's historical tradition of gun regulation, right? So you have to find analogous regulations in history to support a regulation. That's different than the test that had the Court of Appeals had coalesced around this two-step. It's called a two-step test. We can get into that. That's a little bit confusing to me because it's sort of 3 steps, and Bruen itself seems like 2 steps. But anyway, the court rejects this 2-step framework and says that you don't use means and scrutiny in the Second Amendment context. You look to whether the regulation is consistent with history.
Yes, I believe Thomas, in the majority opinion, said that the 2-step test was 1 step too many, effectively wiping out this decade-long trend of using this 2-step or 3. Maybe 3-step would be more appropriate, but determining whether or not the Second Amendment is implicated, and then using effectively a balancing test of what the judges would often call intermediate scrutiny, what critics would usually derisively refer to as rational basis, which is the lowest level of the balancing tests, in order to judge these cases. But still, the higher court did not find that to be an appropriate approach for Second Amendment litigation. And now we have a whole new approach, something fairly similar to what gun rights activists have been wanting and advocating for ever since Justice Kavanaugh sort of came up with it, or coined the approach in dissent that he wrote in another Heller case, right? I believe it was Heller 2.
That's right.
Which was about DC's assault weapons ban, where Kavanaugh was on the wrong side of a 2-1 opinion, but his dissent became very influential in gun rights circles as this what had been called text, history, tradition test. Now I guess Thomas wanted to shorten that down a bit, and it's just text and tradition. I guess the history is kind of implied with the tradition part, but then you also had a series of concurrences, which you actually wrote about over on Duke's Law Center website. Can you tell us a little bit about what you make of those concurrences from, because you had 3 of them, right? There was Kavanaugh joined by Roberts, then Alito had his own concurrence, and then Barrett had her own concurrence as well. And can you just give us your view on what do those concurrences say, and what do you think they mean, in the context of this full ruling?
Sure. So it's always a little bit tricky to try to figure out why a justice who, in this case we have actually 4 justices in total who joined Thomas's majority opinion, but also chose to write separately. I don't think that's unusual in a high-profile case like this. Justices simply want to sort of get their take out there, and there's certainly no restriction on them authoring a concurrence as well. But I think there are some interesting things to unpack about these concurrences. And the first is that, there's this paragraph in Heller, which gets, I think reproduced or at least quoted extensively in McDonald, that says, essentially, and I'm paraphrasing here, nothing in this holding casts doubt on certain longstanding gun regulations, right? So prohibitions on felon possession of guns, mentally ill, sensitive places. We can talk more about that because that's really an interesting one. But anyway, this paragraph, it got a lot of attention at oral argument in Bruen, and what we see in the opinion is that there's a page or two that talks about sensitive places, where Thomas says, we're not going to extensively analyze or provide a framework for sensitive places, but here's a few things that we think lower courts can consider. But the majority opinion does not reproduce that paragraph. So if you look at the concurrence by Chief Justice Roberts and Justice Kavanaugh, they actually cut and paste the paragraph from Heller and put it in their concurrence. I don't know why, but it's interesting to think about, whether that was a point of disagreement among the justices, right? Because you'd think that if Justice Thomas was, wasn't trying to cast any doubt on this paragraph in Heller and these type of prohibitions, that he would have been willing to put that verbatim into his majority opinion. That's not what happened. Well,
he does quote it at one point.
Yeah.
He doesn't reproduce the entire paragraph like you're mentioning there, and they do. And you're right, they do emphasize that in the Kavanaugh-Roberts concurrence. I mean, that the Kavanaugh-Roberts concurrence is kind of all about this is true, but doesn't mean we're, throwing away these other possible restrictions.
Right.
Shall issue permitting is perfectly fine as long as it's, you're actually doing it and not just using it as a fig leaf to not issue permits. But, so it certainly is, they're sort of re-emphasizing that this doesn't mean that all gun laws are now unconstitutional, which was kind of the point of the initial paragraph, right, in Heller.
Exactly.
Just to re-emphasize that this just applies to the thing we're talking about. Bruen goes a little further than Heller just because now they're giving a more, they're spelling out how lower courts should approach these cases, right? But it still doesn't, they're not striking down all kinds of different laws. They're just dealing with the gun carry law in New York, and then they're moving to the how to decide these Second Amendment cases going forward, right?
That's right. Yeah, and as I said, it can be perilous to try to determine why a justice decides to write a concurring opinion. But it's notable that's emphasized,
yeah.
And I think Alito similarly emphasizes the point that you mentioned about may issue versus shall issue. Right? He says nothing. We're not dealing with shall issue regimes here. Those are fine. Nothing we've said here should cast doubt on them. So, again, just a theme that runs throughout those two concurrences. That at least as far as the holding that Bruen is limited to the type of permitting regime that New York had, which these other few states did as well.
And then Barrett looks at your analysis of Barrett's concurrence. I thought was really interesting because I thought a lot of the same things. She brings up this point, which is important, about all right, well, if we're going to be using tradition, how this how states and the federal government have traditionally regulated guns, as a guide for whether or not a modern regulation is constitutional or not. Well, how do we actually make that determination? Where are we looking? Do we look at right after the ratification of the Constitution? Do we look at after the ratification of the 14th Amendment, because we're using that to incorporate the Second Amendment to the states? And she doesn't really answer, because she says it's kind of doesn't really matter in this particular case because the laws at those two periods were similar anyway. But she doesn't, like you said, she didn't really give an answer, right?
Right. And I think, I think you're right. It's a little bit odd in that she sort of raises these historical issues, but then says, I'm just writing to kind of put them out there. I guess she agrees. She does agree with Thomas that they weren't necessary to decide Bruen itself. But these are important issues, albeit I think a little bit technical, and this question of this sort of ongoing legal debate about, where do you look, when the Second Amendment or another provision in the Bill of Rights is incorporated against the states through the 14th Amendment, what history do you look to, right? You could either look to the time that that original language was ratified in the Bill of Rights in 1791, or you can look to the time that the 14th Amendment was passed in 1868. And, I think no matter what you think of the court's historical analysis in Bruen, there are certainly going to be cases where the answers are different, and the answers depend on whether you look to 1791 or 1868.
Right. And so that's, I mean, down the line, I mean, she makes a good point about down the line. This is going to matter a lot, especially if this isn't limited to just the Second Amendment. It's going to matter a lot in Second Amendment cases, but Thomas talks about in the majority ruling that this kind of analysis isn't really limited to the Second Amendment. They use it in First Amendment cases as well, and so forth. So she raises an interesting question, but doesn't do too much to give us a real answer on. I mean, I guess it's just like we need to figure this out at some point, guys. Like, so we should probably give guidance on this, and I think you got it in your piece on this. There was, talk about how our court's going to handle this. So what do you think this is going to ultimately end up with, as far as, courts putting this into practice?
Yeah, that's a great question. And I think it's really an open question. And it's something that, I think people have some concerns about, right? How is this focus on history going to be implemented and applied, especially at the lower level of the federal court system, right? With district courts, when you consider that the Supreme Court in Bruen had the benefit of, hundreds and hundreds of pages of amicus briefing, expert historians, right? I mean, they had a lot of resources available at their disposal to unpack the history here and to kind of figure out exactly what historical laws were around, right? And then they can take those laws and analyze them. And there's some concern about how judges at the district court level, I mean, at the appellate level, there often are amicus briefs. They have maybe more resources, but at the district court level, judges don't really have experience of doing history in that way. And they don't have the benefit of amicus briefing. It's kind of unclear. I think there are, something that we've seen and will probably continue to happen is that we'll see historians being called as expert witnesses. But I don't know the answer. And there's an interesting footnote in the majority opinion where Justice Thomas responds to Justice Breyer's point on this, right? Justice Breyer sort of raises this question of whether the framework will actually work in practice. And Justice Thomas says, well, we rely on party presentation, right? So you rely on the government to come forward, to do the historical work of kind of figuring out what laws might be analogs, and then the challenger can kind of take those apart and say, here's why I don't think they're analogous. And I think that's certainly a fair way to look at it, but I think there are hard questions out there. Like, for example, what do you do if neither party raises a law that then at the appellate level gets, somebody writes a brief and says, hey, nobody brought this to the court's attention, but this is directly on point, right? You can even see instances where there are, new archives discovered, or, this is not kind of a static thing, right? As we're going back and looking at the historical record. So I think there are going to be some, there's going to be some growing pains, certainly. I don't know how exactly the lower courts will do this. And I think it'll vary a lot depending on what kind of resources they have and who the parties are in the case.
Yeah, that's probably true. I think that's probably a critique you could give of, balancing tests as well. How does a judge balance whether or not, a law is narrowly tailored to meet a compelling government interest? Like, it's a lot of it's judgment calls, right? It's right in the name of the.
I think that's
job,
fair.
right?
I think the thing I'd say on that is that it's interesting, right? Because when you're looking at historical laws, the idea behind a lot of originalist thinking is that these are facts, right? You're finding facts, right? You're not dealing with legal arguments. So,
right.
There's generally deference to fact finding, right? But the fact finding is here, who is going to do the fact finding, right? And that's sort of the question: how are these facts going to come before the court? Will there be deference given to the facts that are found at the district court level, at the trial court level? Should there be? So I think there's some questions here. I think it's going to be a little bit different than what what had happened under the two-step framework, right? Because there you're dealing with arguments that the government's making, saying, this is why, X law is empirically, is going to accomplish our objective of public safety or something like that.
Yeah. Of course, the common critique of that two-step test was that it almost always upheld whatever gun regulation was being challenged. And I think maybe that's part of why, like one thing I wonder is whether the court kind of got fed up with what the lower courts have been doing, especially places like the Ninth Circuit, which was just upholding everything, which a lot of gun rights advocates obviously got very fed up with that. But do you think that played a role in the courts, the way they went about handling this case?
I think that's probably fair. I mean, you can see some of that coming through in, Justice Thomas, for example, had dissents from denials of certiorari over the years, right, where he said, we're not, lower courts are not faithfully implementing Heller. So I think that's definitely part of what's going on here. It's interesting, and you actually brought this up earlier, right? It's interesting that the historical tradition test, we'll call it, that the court actually implements in Bruen. This is something that post-dates Heller, right? This is, Judge Kavanaugh, Justice Kavanaugh, when he was a judge on the D.C. Circuit, kind of is credited with pioneering this test in, I think, 2011 in that Heller 2 case. So, it's not that, and there's a lot of debate between the majority and the dissent over, what did Heller say? Did Heller rule out tiers of scrutiny? Did it just leave the question open? But yeah, I think, as it became clear how, what test was being adopted at the appellate level, I think there was certainly frustration among the originalists on the court that, this is not what we meant in Heller. Was it clearly explained in Heller? I don't know. I think that's a matter that can be, you can go back and forth on for a long time, but that's definitely part of what's driving the decision here, I think.
Yeah, I mean, Heller was, I think a lot of this comes out of the fact that Heller was a compromise decision that he needed Kennedy to be on board to vote for it, and Kennedy didn't want to write a ruling or sign on to a ruling that had extremely broad-reaching consequences immediately. Right. I don't know. Like, they just wanted to deal with can you ban all handguns for use inside of the person's own home? You read Heller and it's setting up this, here's the bare minimum of what the Second Amendment protects. And to assuage any concerns about, just radically reworking the whole system overnight of gun regulation in the United States, they put in a couple paragraphs that said, look, this doesn't, there's all kind of, in theory, there's the things you can do. It doesn't mean that there's no regulation possible. It's not an unlimited right. That's what what Scalia wrote in there. And, so you had to build out a comprehensible test from that ruling. And that's what Kavanaugh tried to do because, all right, well, how did Heller come to this decision? That says some regulations are acceptable. Some that might not survive, for instance, strict scrutiny, could still be constitutional under the Second Amendment. Things like the National Firearms Act, the ban on M16s, right, which is explicitly mentioned, or at least alluded to talk specifically about banning M16s. But, how can that be constitutional under the Second Amendment, under a strict scrutiny point of view? Well, we're not using strict scrutiny. We're not using balancing tests. We're using this specialized look at history and tradition of the United States. And so now they've built that test out into something more formal in Bruen. That's how I look at it. I don't know if that matches with how you view that evolution.
I think that's certainly the intent, and that's certainly the idea. I think one way, and it's interesting. I was looking this morning back at the oral argument in Bruen, and this comes up a lot. Justice Barrett raises this when they're sort of talking about there's this back and forth about what could New York designate as a sensitive place? Could they Times Square? What about Times Square during New Year's Eve? Justice Barrett says essentially doesn't this all come down to levels of generality? right? She says, isn't this all just a question of, at what level of generality are you examining the historical record? And, in Bruen, I think the court pretty clearly takes a narrow view, right? The court says, look, we need to find a historical analog of a state limiting public carry to people who showed some special need, right? I don't know that you could get any more specific than that, right? That is what the New York law does. You could certainly get broader, right? You could say, well, we're looking for laws that restricted people from carrying weapons in public in dangerous ways, right? There are infinite levels that you could do, but you could go up. And I don't know, a lot of how this test works in practice will be at what level of generality do judges apply it. And it's going to be tough for judges to be consistent. I think we're going to see variation in different circuits. I think we're also going to see variation in these different categories of challenges that we'll see, right? So we'll see challenges to where restrictions, right? Location restrictions, sensitive places. We'll see, who challenges, right? Challenges to what groups can be prohibited from possessing guns. We're going to see challenges to what, right? To what type of weapons, assault weapons, magazine bans, things like that. And I think there's definitely going to be some, there are definitely going to be judges that, allow their own opinions about the law, allow their proclivities, their feelings about the law to sort of dictate how they do the historical analysis, at what level of generality they do it. You can think about things like, the sensitive places doctrine, right? And the sensitive places cases that will come up, right? At a high level of generality, you could say, well, what are the historical laws where legislatures, banned guns in locations where they thought guns were especially dangerous, right? That would be the high level. A lower level might be, if you look at what Justice Thomas identifies in the opinion, it might be something like, places where people engage in important political activities, right, or things that are central to the democratic process. And I don't know how those will come out, but I will say that I think there's a lot of room there, and I don't know. I'm not sure that the framework is as constraining of judicial discretion as the majority might hope.
Yeah, I think that's one of the key points here when you're talking about the impact of this ruling and this new test is it's probably not as broad as gun rights advocates would like it to be, or it probably won't be as broad as they'd like it to be. And it's probably, or as broad as gun control advocates fear it will be, right? Just because there's so much you can do with that, this idea of what constitutes a tradition of regulation in the United States when it comes to guns. Because, there was an amicus brief in this case that took the route of looking at, historical regulation of gun carry in the United States and made at least a decent case as to, not a totally laughable case as to how it could be upheld under New York's law could be upheld under a historical statute. Now, obviously, the court rejected this in the ruling, and I think that the court's analysis of that specific question makes more sense. But it's not hard to see how a different balance on the court would come, even if they were using the exact same standard and same set of facts, could come to a different conclusion on that point. And I think that's what you're going to see oftentimes at the lower courts that are inclined to give the state more deference when it comes to regulating firearms than perhaps Justice Thomas is. If that makes sense. The more liberal courts will probably go in a direction that says there is this tradition of regulating guns in all kinds of different ways in the United States, even at the founding era. And if you look at it from a certain point of view, if you step back just a little bit further, it fits. There's an analog, because the court doesn't require you to have a literal copy of the modern regulation be found in historical tradition. You just have to find an analog that is associated. Now,
well, more than one analog, but yes.
Right, you're right. It can't be just a single outlying law, because the court addressed that with the New York case as well. But you understand what I think I completely agree with what you're getting at there as far as how this is likely to come out. Although the only thing I do want, I think it will be harder to uphold some modern regulations and some of the biggest ones, some of the big ticket ones under this new standard than under the two-step test that was in place earlier. Things like assault weapons bans, things like permit to purchase laws, especially ones that are extremely difficult to actually navigate in practice, like in New Jersey, for instance. The magazine bans, maybe universal background checks, even. It'll be. What do you think is going to be the practical impact? Practical impact on those policies in the short term and then in the long term, because they might be different, right? Right.
And I think, maybe if we're, just to step back and talk sort of more broadly about what the impact of the decision is, I think there's the narrow impact, right? There's the, to take us back to what the Bruen case was about, right? There's the impact on permitting, on concealed carry permits, right? So you've already seen, I think, all of the may issue, or the states that the court categorized as may issue, either like New York, passing a new law saying we're getting rid of proper cause. We're also doing a lot of other things, which we can get into.
And actually,
go ahead.
Well, go ahead. Sorry, you finish your point, but I want you to ask a follow up on that.
Yeah, sure. My point was simply, you've seen New York do that. I think every other state that the court placed in that category has done something similar, not necessarily amending their laws formally, but having, the state attorney general has issued an opinion letter saying we're not enforcing our proper cause analog. But I think, there's definitely still, there are still outstanding questions on even concealed carry permits, right? There are moral character or suitable person requirements in, I think all of the may issue states have them, and certainly some of the shall issue states did as well, right? So to what extent do those allow for discretion? Are those still okay? It seems like the court says yes, but where is the line, and what are states still allowed to consider in terms of the reason that a person wants to get a permit?
That's interesting. You think that those sort of good moral character clauses aren't functionally identical to the proper clause? I understand that in one, you have to prove you need this permit for a particular reason, but the other one, you have to prove that you're a good person or whatever that means. But they both seem like clearly completely subjective, which appeared to be the main issue with the good reason clause in this case, right?
Right, and I think that's sort of the interesting twist on this opinion, is that the court says these shall issue jurisdictions don't have to make changes, but some of them have these types of requirements in place, right? So it's not really clear what to make of that or where we go from there. And I think it comes down to some litigation there. Right?
Yeah,
I think that's probably right. I think for a lot of the permit stuff, there's been. Again, we can talk, if you want, we can talk more about the New York law, and I've written a post about that as well. But, I think a lot of this stuff will play out as an as-applied challenge. And that's what we see the court saying in Bruen, that even if you implement shall issue, you sort of get your permit system the way that it needs to be, according to the court, you can still have an as-applied challenge, which is not anything unusual, right? If it's applied in a way that is too cumbersome or has exorbitant fees for applicants, stuff like that.
Right. Yeah, I think that probably will happen in a lot of these former may issue states. You'll see a lot of as applied challenges over wait times and cost and so on and so forth. And those will probably be a little more dicey as to how they'll come out. I think, but some of these laws that have been passed in response to the ruling it feels to me, at least, that the outcome is far less dicey, and that these are just sort of blatantly unconstitutional things that are intentionally thumbing their nose at the Supreme Court. But I'm interested in your perspective, like this, the New York laws that's basically make everywhere a sensitive area. The governor had a quote saying, when she was asked where it would be legal to continue to carry, and she said, presumably some streets, and basically nowhere else. They made the entirety of Times Square a gun-free zone. They've inverted. This one's interesting because it's completely novel. I've never heard of anyone trying it this way before, but they've inverted things to where all public businesses are presumptively gun-free zones and have to put up signs saying they want people to carry there. How do you think these these new laws that are passed in that vein are going to actually perform in court?
Sure. Yeah, I mean, it's a great question. It's a question that I'm sure, there have been legal challenges already to New York's, to the law that New York passed. Those will take some time, I would imagine, to work their way through the court system. But I think, to take the sensitive places, the designation of sensitive places as an example, I think that's maybe the most high profile part of this law that, as you said, New York has a very expansive list, right? They include, Times Square, bars, park, zoos. But there are just it's a very
public
very long
transit
list. Public transit,
yeah.
Yep. It's not that there's not, as I said, there's not a ton of guidance in Bruen about the sensitive places issue. The court discusses it briefly, but this is going to come down to at what level of generality are courts looking to history, right? Are they, if you take a narrow view of the places that Justice Thomas listed, I think it was legislative assemblies, courthouses, polling places, those are all places that have a close relationship to government, political actions, voting, right? Maybe that's kind of the defining principle there. But you can think of other ways that you could do this analogical reasoning, right? You could say places of public assembly. The court seems to cast doubt on that, right? Because Manhattan can't be a sensitive place just because it's crowded. You can think about the proximity of law enforcement, the availability of law enforcement in a certain place. It's interesting, even within the brief passage in Bruen, there's not really an explanation of why the historical sensitive places that are identified would support banning guns in schools, right? That's something that is in Heller. I think, or this is something that the court has been saying that banning guns in schools is okay. But again, it's going to depend on the level of generality at which a judge looks to history, right? Because there are historical laws out there. I think there's a fair amount actually from the South and the West in the 1800s, late 1800s, saying you can't bring guns to places where people assemble, and then they list certain places, right? If you go further back, there are prohibitions on carrying guns in fairs and markets in England, right? So it's simply going to be a question of how do you do that analogical reasoning, and there's not a ton in Bruen that we can go off of to predict.
And I think I just think one of the things, and this will be important for the next part, the next question I want to ask you, but one of the things that all of what you're saying highlights is that Second Amendment litigation, Second Amendment case law is just in its infancy at the federal level. Heller was 2008. That was the first case to recognize an individual right to keep and bear arms. It was protected by the Second Amendment. Even Miller was the 1930s, which is the case that, and it wasn't much of a case. There's not much to Miller, but that is the case that Heller borrows a lot from. And it just wasn't much of a question. There was a totally different perspective on what the federal government could do, and what that the federal Constitution only applied to limiting the federal government for a long time, and there weren't federal gun laws until the 20th century, and so there's reasons why it's relatively new area of concern for the court. But I think, a lot of this stuff just comes down to, well, they haven't addressed this yet because they've only really done like 3 important cases on the Second Amendment to this point. So they're just going to need to do a lot more and lay out a lot more, because there's, in all the case law for the Bill of Rights, First Amendment, Fourth Amendment case law is hundreds of cases long and deals with, there's all kinds of contradictions and quandaries that they get into over the course of that time that they have to adjust later on or provide more detail to down the line. I think that's what you're going to see with Second Amendment jurisprudence moving forward. Like, one of my things is that in order to avoid the lower courts kind of just reverting back to what they've been doing, but under a historical tradition standard, like the court doesn't want them to uphold a lot of these gun laws, at least the more modern ones, then the court's probably going to have to step in a lot more often and take cases to do that. Just taking a case every decade is probably not going to be a viable way of the Supreme Court guiding the lower courts, to put it, in a friendly term, through Second Amendment case law here. But with that said, what do you think are the remaining, obviously we've got the safe space, not safe spaces, the sensitive places exceptions, which I am surprised that New York just went whole hog on it right away. DC got into the same fight, over concealed carry a couple years ago, and then didn't want to take this to the Supreme Court, so they gave up. And I thought that everyone was going to start modeling their laws after DC, because it hasn't been successfully challenged since they went to shall issue, and they have a lot of sensitive places restrictions.
Yeah, I think there was recently a challenge to the Metro.
Yes,
gun ban.
Heller himself is back and challenging that again, and that is probably one of the more controversial parts of DC's sensitive places rules, because it basically cuts off concealed carry for a lot of people who live in DC, just like New York's does. But regardless, what are the other areas that you see as remaining to, as being real open questions? I know there's a lot of critique, for instance, of, the common use standard, this idea that guns that are in common use for lawful purposes are presumptively protected by the Second Amendment. This is something that will likely be litigated thoroughly in the assault weapons ban cases that are coming through the federal courts, including the one that the Supreme Court just sent back down to the Fourth Circuit. But what are some of the other areas where they're just going to need to do a lot more litigation on?
Yeah, it's a good question. And you mentioned the court, granting cert, vacating, and remanding 4 cases that it had been holding while it decided Bruen. And I think one of those cases, the Hawaii case, was very, very similar to Bruen. Hawaii had a restrictive provision in its permit scheme that I think went even a little further in requiring people to show some exceptional need. But the other 3 cases are not concealed carry cases. I think there's an assault weapons ban case, a magazine case. And so, there I think was some thought that maybe the court would actually grant cert and take one of those cases. They haven't. They've sent them back. And I think we'll sort of wait to see what happens there. Just on the assault weapons point, there was I think late last week, a federal judge in Colorado issued a temporary restraining order of Superior, Colorado's assault weapons ban. And it's a short opinion. I think there's a page or 2 of analysis that basically cites some federal appellate dissents and says these statistics show that semi-automatic weapons, are popular or commonly owned for self-defense. That means that they are protected by the Second Amendment. And the judge found that there was a likelihood of succeeding on the Second Amendment challenge there and enjoined the law. Important, I think, to note there that that's an emergency application, right? That's not sort of a full determination of how that will go, and it doesn't appear that there was any historical discussion, right? Of like, is this actually consistent with history?
Right.
Which would be, of course, be the next step under Bruen.
Another important point right there is that he was an Obama appointee, which is interesting as well. Not that every judge is you can predict exactly how they're going to rule based on who appointed them, but it is, it's an indicator, I would think.
Sure. And it'll be interesting to see what happens once there's sort of a more fulsome opportunity for the parties to actually to brief that case. We've seen some courts actually applying Bruen. It's been kind of I don't think like the avalanche that you would expect, just because especially at the federal level, these things can move relatively slowly. But there's been a lot of litigation, as there was in the intervening period between Heller, McDonald, and Bruen, about these group prohibitors, right? So you have criminal defendants saying, I'm challenging the felon gun ban, right? And those haven't gone very far, right? Even after Bruen, the courts are still saying that those are fine. And I think the opinion supports that for the most part, at least as to most of those prohibitors. So I think that's an area where we'll continue to see those cases come up pretty frequently. You mentioned earlier this thing that New York is doing, which is, I think it is novel in that I don't think other states have done it yet, although it may be under discussion in some blue states, which is to flip the private property default, right? To say that that the default used to be that you could, if you had a permit, you could carry your gun unless onto private property, unless the business or something like that, unless the owner posted a sign saying guns are not allowed. Now it's the opposite. The assumption is that you can't carry there unless explicitly allowed, and that's a tricky one. I mean, there have been challenges already to that, but it's not really clear what the hook is, right? I mean, because there are also cases out there. There's I think an 11th Circuit case that it holds, and I think it's pretty clear. I mean, this isn't exactly what New York's law does, right? But it's clear that you have the right to keep guns off your property if you say so, right? That's always been true, right? You have a property right to say you can't carry guns in my business if I tell you not to.
Sure.
So
although there have been some exceptions with like employees and cars and parking lots and stuff.
Sure,
yeah.
Sure.
But generally, yeah.
So I think if we see other states doing that, I think it'll be fascinating to see what types of challenges there are. I'm sure there will be quite a few.
Yeah, absolutely. I mean, it'll be I think there's just a lot left for the court to weigh in on and get a real record of. Now we had that the Second Amendment means at least this thing, which is that you can keep the most popular kind of gun employed for self-defense in your own home. Then now Bruen has expanded on that and given us a test of how to handle Second Amendment cases. And I'm sure that test is going to be refined over the coming decades, hopefully for a lot of gun rights advocates. Maybe the coming years, instead of having to wait 12 years between each ruling from here on out. But I just think there's a lot of open questions, and I imagine you guys will be writing about all of them over at the Duke Firearms Law Center. Can you tell people where they can read more from you and the other experts that you publish there?
Yeah, absolutely. So you can go to firearmslaw.duke.edu. That's our website. As I said, we host the repository of historical gun laws, which we're in the process of building out after Bruen, and I think is going to be an important resource. And we also have a blog, Second Thoughts, which you can find on our website, and we're on Twitter at Duke Firearms Law.
All right, wonderful. Well, thank you so much for joining us. We appreciate you giving us the time here.
Thanks so much, Stephen. It's great.
All right. It is time for our news update. Contributing editor Paul Crookston here. Stephen, what are we talking about this week? I'm thinking it's the assault weapons ban.
Yeah, sort of a surprise move this week after initially announcing they were going to push this vote to after the August recess, which would have been probably about 2 weeks from this point, they made a big reversal. They broke up the package that they had tried to put together with this assault weapons ban, and instead just went straight to the floor with just the ban. It had been paired with this police funding bill that moderates wanted to get through, but was ultimately blocked, at least for now, by the Progressive Caucus and the Congressional Black Caucus, who didn't like some of the language in the bill. They wanted more, I guess, robust provisions for police accountability to go along with this funding. And that basically held up that part of the deal. And it turned out that the moderate Democrats, I guess they just got rolled. There's a promise that they'll continue on that part of this deal, but it's just a promise at this point. So instead, the bill suddenly Friday went to a vote and passed. It passed by the thinnest margins. It was 217 votes for, 213 against, one non-vote. Republican didn't vote. I'm not sure who that is actually, but you had 5 Democrats cross over to vote against the bill, and which meant they needed a Republican, at least one Republican, to vote for it in order for it to pass, because it needed to get at least 216 votes, given that everyone was voting, and they got 2 Republicans. So they got Fitzpatrick from Pennsylvania and Jacobs from New York, who Jacobs, this is his big hurrah vote. He said he was coming out for this ban on sales, and that got so much backlash in his district that he's now retiring. But he did end up voting and was a key vote to make this happen. Now, to be clear, this is just the House of Representatives. It is a big deal because this is the first time they've passed an assault weapons ban since the first one, the 1994 assault weapons ban, which expired in 2004. No House has actually voted on an assault weapons ban since then. And this is the first time it's passed by the thinnest of margins. It's a thinner margin than what the other gun control package passed by. The lowest one there, they actually kind of duplicated part of that package because the last month's gun control package that the House passed had a magazine ban in it. And so does this assault weapons ban. So Congress has been, at least when it comes to guns lately, they've been really into just redundancy. They've been passing things that are either already law. For instance, they created a new crime for straw purchases, even though there's already a crime for straw purchases. So they've done a number of these things, and now the House has passed 2 separate, though I believe completely identical, magazine bans. But the previous magazine ban got 220 votes, which was the lowest of any of those proposals as well. But now this new assault weapons ban got 217. And it will move to the Senate, where probably nothing will happen, to be honest with you.
Yeah, it's not like it'll lose. It probably just won't go anywhere, right?
It probably won't get a vote. That would be my guess. It could get a vote. It's not impossible. Schumer could bring it to the floor. The schedule is super packed on the Senate. It's packed on the House side too. They only have, probably another 20 days of actual legislating until the midterms, maybe a little more than that. The August recess, they're going to come back early from that to finish some other work. Maybe they'll, there's probably opportunity to do something during that time. But either way, even if they do find the time, there's just not the support by a long shot in the Senate, because you'd need 60 votes first off, and you're not going to get 10 Republican votes. You probably aren't going to get a single Republican vote. There isn't a Republican senator who has come out in support of this policy. And then there are a number of Democrats who are unlikely to vote for it as well.
It's not like all 50 Democratic senators are co-sponsoring this, right?
No, there's only 37 co-sponsors. Now, you'd probably get more who would vote for it, just like this House bill had It was about 210 people who could actually vote on it were co-sponsors, and it ended up with about 217 votes. So, there's 37 co-sponsors on the Senate version of this bill. You maybe could get to 45 if you really tried hard. I don't know, maybe more. It's hard to say exactly, but there have been multiple Democratic senators, including John Tester, and who've come out to say they don't want to. They're not for an assault weapons ban, and I highly doubt that even some of the ones you might be able to pull over to the yes side would actually want to take that vote 2 months before an election. But you never know. The other problem with the Democrats in the Senate taking the vote is because you're likely to see Democrats vote against it, it sort of undermines the message here, which is that Republicans, it's kind of already undermined a bit, but the message is that Republicans are blocking this from becoming law. And so if you go to a vote in the Senate and it's Democrats who keep it from getting to 50 votes, well, it kind of undercuts the message, although it needed Republicans to pass the House anyway. It only got 2. There's an obvious party breakdown here. 215 Democrats and 2 Republicans supported it. So it's not exactly a shining example of bipartisanship, but they couldn't have passed it without those Republicans.
Yeah, it's still technically bipartisan. So the idea, I know what you mean. The narrative is unclear. And I guess this leads into what I think is one of the many interesting things about this. What do you think is the motivation here for the Democratic caucus?
Well, I think it's certainly a messaging bill. This is part of their message going into the midterms. They understand what they're up against. The economy is doing very poorly. We've now entered into a recession after 2 quarters of negative growth.
Have we?
Right. And there's what most people would consider a recession, at least. We've got inflation at all-time, at the 40-year highs, and you've got all these problems with the economy. And people are very unhappy. Gas prices are through the roof. There's all these other issues that are kind of at the top of people's minds. And you can see this when you look at polling on issue importance. Guns is up a little bit from where it usually is. Usually it hovers around 1% to 3% of people consider guns the most important issue. It's the most recent polling I've seen had it at 4%. Of course, in that poll, we wrote about this at the Reload. The president's approval rating on guns is dismal, just like it is on basically everything. So the idea that making gun control a big part of your push for the midterm elections is questionable at best, I think, in this environment. And then using this particular policy is even more of a stretch, I think. The thing is, they have already passed successfully a gun control bill this session. It's the first restrictions on who can own firearms in the last several decades. And they got that through on a bipartisan basis, and the president signed it. So they had, an accomplishment. They had a win. And now they're which was a pretty good win for moderates too, because, as significant as it wasn't, an expansive ban on guns like this bill is. And this bill is not that popular anymore. This policy is polling below 50% now. It's at all-time lows in the Quinnipiac poll. And even in Morning Consult's polling, which still has support a bit higher than Gallup and Quinnipiac, you're still seeing no sizable increase after Uvalde, and it's still down several points from its high point back in 2019. So as they're doing this for the first time, the policy that they're pushing is losing popularity.
It's a very interesting, I admit, I've covered politics for a while. It's hard for me to get my head around this one. They had a win. They looked kind of statesmanlike for all the reasons that you explained with the previous gun control bill. It was something substantive that got passed. And now you shoot for the moon on this, and it's pretty, it's a long shot to even get taken up in the Senate. Is this a case of the progressives running the show? Like, is there an activist? Is there just a real activist energy around this particular policy that Pelosi just felt like she couldn't resist?
Yeah, I think so. I mean, look, this has been a marquee policy for liberal Democrats for decades. This has been the thing that they talk. There's two policies that they talk about: universal background checks and an assault weapons ban. And by the way, just to give everyone a little bit of background on what exactly this bill does, because assault weapons is a nebulous term, right? It means something different in each state where there's an assault weapons ban implemented. This bill would use the 94 definitions or something very close to them. So a center fire rifle that accepts detachable magazines and has certain features, including, pistol grip, barrel shroud. They even kept in some of these 90s features that no guns really have anymore. The bayonet lug, flash suppressors, adjustable stocks. Those sorts of things are what makes something that's the same caliber, same size rifle, same length of barrel. It makes one regular gun, I guess, a regular rifle, and the other one an assault weapon. That's banned. Now this one, the 94 ban, you could have one of those features you could have on your rifle and it still would be fine. This ban goes further and makes it so you can't have any of those features. So it's much more expansive in practice than the old ban, but it's very similar in terms of definition. It also affects some semi-automatic shotguns and some handguns too. The handguns by weight, where they're trying to go after like the AR and AK pistols. Because your gun can't, your handgun can't weigh too much, or else it becomes an assault weapon. And then they add some stuff like pistol braces, which again is kind of redundant because of the weight thing. Like the whole point of the weight requirement is that they don't want AR pistols and AK pistols to be allowed under this law. And so AR pistols and AK pistols are what you put pistol braces on, but so they've also made it redundant and banned those as well. They also clearly have no idea. The bill's sponsor, Cicilline, Rep. Cicilline, has no idea what a pistol brace is. We learned in the hearing on this bill, because he thought that it is the same thing as a bump stock, and that a pistol brace will make your gun a machine gun, which is just it's completely absurd. But anyway, regardless of all that's what the bill does. And I think it's important to be clear on this. You see major outlets struggling to describe these things because it is nebulous. I mean, the Associated Press, bless their heart, they've tried to improve their reporting. They put out an update to their style guide that said, avoid these terms like assault weapon, assault rifle, military style rifle, because they're nebulous, they're politically charged. And so when they reported on this, they tried to substitute assault weapon with semi-automatic guns. But the problem there is this assault weapons ban targets a specific subset of semi-automatic guns.
Not all semi-automatic guns.
Outlaw all of them. And so that becomes misleading. They later changed it to certain semi-automatic guns, which is accurate, which is a much better way of describing it. I just, for us, we try to do, I use assault weapons in quotes and then try to explain what the heck
any particular bill.
Context.
Exactly.
Yeah. And like examples of the specific, like they're targeting AR-15s and AK-47s.
Yes.
That's what they want to go after. That because they view those as particularly dangerous, and they show up in high profile examples of mass shootings, of course, including Uvalde. And so that's the motivation behind these bans. But they of course, go well beyond the AR-15 and the AK-47 to lots of other kinds of guns as well. And so it's important to try and explain that to people so they can understand what the heck is going on. But yeah, so this bill, it made it through the House. I mean, they're going to run on this bill, some of them, and it will be interesting to see how that works out. To me, and we'll have more on this over at the Reload probably for members soon. They'll write about this for the members newsletter this week. But I mean, the only people this helps in theory are the ones living, the ones in districts where they need a lot of activist support they want to fire up the liberal activists in the area, the gun control activists. And so this is, passing all those other stuff wasn't enough for most of those activists. Even this bill, David Hogg was like protesting this exact bill during the hearing on it for some reason. It wasn't very clear to me, but he celebrated the passage of it in the House. But the problem, I think the ultimate problem with that strategy is like, it's still not much of an accomplishment because it's not going to become law. So you pass it in the House, but Democrats are going to block it in the Senate, whether it comes up for a vote or not. So I don't know. I mean, I guess in your individual race as an individual House member in like a Biden +7 district, maybe that has some sway with the activists there. But, it's one of these things where it's like the gun groups also on each side have become so they've become so captured by partisan politics that like, what is Giffords and Everytown going to do if you don't pass this bill anyway? They're still going to give you millions of dollars. They still want you in office because they don't want your opponent. So, the only thing you're pushing for now is hopefully that this impacts grassroots enthusiasm, which, I mean, will it? I guess that's the open question. I don't see a good case.
Yeah, if I put on my pundit hat, it seems like Democrats right now are panicked about enthusiasm. And they're just like, what's the classic Democratic issue? The assault weapons ban, like you said, it's a marquee policy. It's not as popular as universal background checks, though, right? Where is it polling right now?
No, it's not even close. It's polling at 49% to like 45. So, and the other thing about it is, and this has been the old cliche, but I think the enthusiasm gap benefits the pro-gun side. It's just, I just think that a lot more people are going to be motivated to come out and vote against somebody who voted for this bill. And that's going to hurt those swing district Democrats a lot more than it's going to help any D+7, D+10 Democrat in practice. I guess the thing is like, those guys are probably already, they're lost anyway.
Yeah.
Just because of the atmosphere that they're running in. So
I don't know.
It might not have much of an impact at all, to be honest with you.
I don't know about you, Stephen, but I feel weird every time I say that I know more about a political party's interests than they do. It's a very presumptuous thing to say, but I can't escape the conclusion that this is just stupid. This is just politically dumb. They're at a critical juncture before the midterms. I think they're doing something that, for some weird combination of reasons, they've convinced themselves is going to help them, and I don't think it is. I think it's just a blunder. I hate to be so simplistic in my thinking, but I can't find an angle where this makes sense to me. And you were talking on Twitter about how you felt like it wasn't going to happen because it didn't make sense and people pushed back on you and stuff. And I think there's just the common sense political reasoning to me is very clear that this is not something that's going to help them.
Yeah, I don't see it working out well. I don't think it's going to forestall this this coming red wave that you're going to see in the House. I don't know that anything's going to. They're trying to use wedge issues, abortion and guns. classic play, I guess. But they're focusing. One of the problems they had is that they already passed all the other gun control bills. They already did a ton on guns before this. So this was the last big thing. And I just don't know how it's going to help in reality. And now look, there's another aspect to it of like, they know they're going to lose the House and who knows when they'll get it back again. So maybe it's a last hurrah kind of thing. You know, I'm sure that many of them genuinely believe in this policy and think it will help with mass shootings. And so you can't completely disregard that, as much as we all know how politics really works. But you know, I'm sure there's some part of this is like, they really believe in this policy. They really don't think people should be allowed to own these guns. And their beliefs match their rhetoric to at least some degree. And so this was the last chance to do this bill for probably a long time. And, you know, to Pelosi's credit, you know, she got it done. It didn't seem possible, but she walked the razor's edge here to get this exactly the number of votes it needed to pass, +1. So, you know, like, I always said, I didn't think the timing made a lot of sense the way they were doing this, but I always said that if it got to a vote, it would probably pass, and it got to a vote and it passed. So we'll have to watch how the political fallout goes from here. I know one thing I know is that all these Democrats that are going to lose, that probably would have lost anyway. Now the gun rights groups are certainly going to count every single one of the people who voted for this and say they lost because of it. And I don't know if that'll be true or not, but it's definitely something that you're going to see.
Yeah.
So we'll be here watching the whole thing, but that's it for this week. Thank you guys for tuning in. If you really like the show, request that, and you listen this far, I mean, you must be pretty dedicated to get all the way through. Please go and leave a rating on Apple Podcasts or whatever app you use. It really helps the show grow, helps more people find it. Share the links, you know, on your social media and with your friends. If you like what we're doing here and want to support us, you can also head over to thereload.com, pick up a membership. That is how we fund ourselves. We're a very small publication, as you could probably tell from the podcast. You know, there's only a few of us doing this work, and we really rely on our members to make it possible. Would not happen otherwise. You'll also get early access to this podcast and the opportunity to appear on the show. If you are a member and want to come on, just reach out. We'd love to have another member segment soon. But yeah, that's it for this week, and we'll see you guys next week.